I would like to draw your attention tonight to the problem of regime change in politics and how it affects international law and vice versa. Generally, the idea of regime change is in no way a new fact on international scene. Of course, nowadays it gains several new features like so-called democracy claims or the use of new technologies. But the very fact is an old one. What is really new, and that should be underlined in the context of the regime change, is a new regime of international law. I even may say that the new international law is establishing in front of our eyes. Step by step, very quietly, last 20 years, we are witnessing a process of the establishing of the new international law. But before we analyze this phenomenon, let's have a look at the several so-called strange facts that is going on in the very legal institutions of the modern world, international courts and tribunals. Let's concentrate on the activity of International Criminal Court. The very first case in this court, the so-called Lubanga Trial. The first prosecution witness, right in the courtroom, confessed that he was given the false evidence. The court did nothing towards the prosecution. In the case against Mr. Uhuru Kenyatta, the prosecution withdrawn the case against other accused after the charges were confirmed by the court. The trouble of this situation is that the prosecution said that there is no evidence against that accused. But the court already confirmed the case, and you understand that the court could not confirm the charges without proofs. So the question, how the court confirmed the charges against the accused? After Mr. Kenyatta became the only accused in that case, the prosecution said that there is no witnesses in his case too. The start of the trial was postponed instead of case to be dismissed. The case of the president of the Côte d'Ivoire, Mr. Laurent Gbagbo. Mr. Gbagbo was imprisoned by the ICC, International Criminal Court, for 2.5 years without confirmation of charges. In any local legal system, no person could be detained without confirmed charges. The first hearings for the confirmation of charges were finished with an agreement of judges that there is no case. But the judges given the prosecution more time to collect more evidence. Some weeks ago, the International Criminal Court finally, after almost 3 years, confirmed the charges against Mr. Gbagbo. The decision was adopted by majority of judges 2-1. The dissenting judge claimed that there is still no case. But when defense appealed the case, all the judges deny their right to appeal. In the case against Muammar Gaddafi, after the assassination of the accused, the court simply, I'm quoting, terminate the proceedings. We all see that who was killing Mr. Gaddafi. It was filmed, it was demonstrated, but court decided not to proceed with this crime. They simply terminate proceedings. During the trial of the former Vice President of the Democratic Republic of the Congo, Mr. Jean-Pierre Bemba, all his defense team was violently arrested. During the announcement of the judgment in the case of Mr. Chui, it's also democratic of the Congo situation, the presiding judge said the following, and I quote, "Mr. Chui, the fact that we are acquitting you does not mean that you are innocent." I don't think we need to comment that. What was very interesting, the same judge delivered in several weeks another judgment against Mr. Katanga, and Mr. Katanga was found guilty. And we were all really excited because we expected the statement that Mr. Katanga, the fact that we have found you guilty means you are innocent or something. But unfortunately, he was found just guilty without any additional comments. But this case is still very strange because Mr. Katanga found guilty, but not in charges that brought to him by prosecution. He was acquitted by all charges brought by the prosecution, and what happened next? The court brought their own charges against the accused and found him guilty on these charges. So, there are many other unbelievable incidents that are going on in the courts and tribunals, and we have a very exciting presentation of Matter Christopher Black, who will tell truly unbelievable stories from the International Tribunal for Rwanda. But to understand these strange facts, we have to ask ourselves, is it a bad fact or it is a bad concept? And the main problem to search for the answers to these questions is the contradiction between the official aims that proclaimed by the international courts and tribunals and their real aims. Let's look at the official aim of International Criminal Court. This aim enshrined in Article 1 of the Rome Statute. And this aim is to exercise jurisdiction over persons for the most serious crimes of international concern. The practice of ICC shows that this aim is not achieved. The international crimes are committing in front of ICC, but it has very little interest in them. At the same time, ICC actively involved in the certain conflicts, and it would be difficult not to notice that this activity in many cases are connected with one side of the conflict. But it would be wrong to conclude that ICC does not achieve its real aims. We argue that ICC has two different sets of aims. First, officially pronounced, and the real one. So, what are the real aims of ICC? I suggest to find answer to this question from the analysis of two cases, Sudan case and Libya case. The Sudan case was referred to the ICC in 2008 and the Libya case in 2011. The analysis shows that this case is conducted with great violation of international law, and the graveness of this violation gave us no other explanations but to conclude that it was made in order to destroy the very base of the modern international law. The very referral of the situation in Sudan violates the United Nations Charter. The question, how the Security Council acted referring the situation to ICC, the situation in Sudan. The logic says to us that Security Council should act according to the United Nations Charter. But in reality, Security Council acted according to completely different document. So we have only illusion that Security Council acted according to international law. Yes, it acted according to Article 13 of the ICC Statute. But Security Council should act according to United Nations Charter. And in United Nations Charter, there is no power of Security Council to refer any situations to court. So, we are witnessing the grave violation of the very base of international law. The second problem that raises these referrals is connected with the exact members of the Security Council. Let's take a look who took part in this decision. It was at least 5 permanent members who are well known. It's China, Russia, United States of America, France, and Great Britain. 3 of these countries are not member states of Rome Statute. But these states voted for the referral of the situation in Sudan and Libya to ICC, which means the states who are not member states of a certain treaty oblige another state who are not member states of the treaty to be binded by this treaty. And this is again not a simple violation of international law. This is a destruction of the very basic idea of modern international law. I would like to draw your attention to another very interesting case. Well, it's still Sudan case, al-Bashir case. But in this case, it was 2 interesting decisions adopted by the International Criminal Court, officially directed to Chad and Malawi, 2 African states. But it's a very interesting example. When the decision directed to Chad and Malawi in reality concerned every state, especially states who are not members of the Rome Statute. In this decision, the International Criminal Court says that any head of states now are subject of the jurisdiction of any international courts. Of course, there is no legal base for such a conclusion. But anyway, the precedent is set. Now I would like to suggest to add for our analysis some synthesis. The question is whether it's only bad practice of International Criminal Court. I would like to propose to analyze the activity of ICC in a more broad context and to see how other courts of the system of international criminal justice are operating now. The main courts constitutes the international criminal justice nowadays are International Criminal Tribunal for Rwanda, International Criminal Tribunal for former Yugoslavia, Special Court for Sierra Leone, Special Court for Lebanon. Let's start from the question how these courts were created. Probably a very formal question, but with very interesting conclusions. International Criminal Tribunal for former Yugoslavia and for Rwanda were created by the resolutions of the United Nations Security Council. According to these resolutions, the legal base for their creation is Chapter 7 of the United Nations Charter. But if you look into this chapter, you will realize that there is no any authority for the Security Council to create tribunals. It's again was created an illusion that the Security Council acted according to international law. If we look into the legal base for the creation of Special Court for Sierra Leone, we will again realize that this court does not fit into the constitution of this country. The constitution of this country enumerates all the bodies of judicial system of Sierra Leone and no special court mentioned. If we look into the legal way of creation of special tribunal for Lebanon, we will see the same situation. Here on the screen you see the citation from the representative of Russian Federation. Unfortunately, Russia abstained from voting, but the abstention explained with quite hard words. And again, during the creation of this tribunal, another precedent was set. When the international treaty was entered into force without will of one of a party. It's again not a simple violation. It's again the fundamental destruction of international law. So, to conclude, we see that all international courts and tribunals were created illegally. But I would like to draw your attention to the activity of the courts. Probably, as some lawyers argue, well, they agree that the legal foundation for their creation is doubtful, but they are making a good job. Okay, let's look at how good this job is. But because of the time restriction, I would like to draw your attention only to one court, probably not so well known, and its activity. It's a special court for Sierra Leone. Quite a short moment from the activity of this court. This is a trial or panel of judges on the most important trial that was conducted by this tribunal. This is a trial against the former president of Liberia, Charles Taylor. Here you see the 3 members of the bench. But in fact, it was not only 3 judges, but 4 judges. And this 4th judge is quite an important person for our analysis today. This is the judge Al-Hadji Malik Sow from Senegal. Please have a look at the bench before the judgment. Okay. And look at this after the judgment. So it looks like it was a judgment not against Mr. Taylor, but against this judge. What happened? This judge, after announcement that Mr. Taylor is guilty, start to talk, while other judges very quickly stand up and leave the courtroom. The technical assistants very shortly switched off the sound, but we still heard the judge said that there was no deliberation about the judgment. He said, we did not discuss it. I don't know how these other judges received the text. It happened in open court. After this statement of this judge, he was removed from the bench. But it shows very sharply what's going on in the so-called international justice system. I still have some examples, but I have to switch it and come to my conclusions. What we have now, what we are witnessing now, is not just a use of double standards. It is not just a violation of international law. It is not just a destruction of international law. We have a very serious deformation of international law. What kind of this deformation? I enumerate the main features of this deformation. The most important thing is this is the destruction of the very foundation of international law. This is the destruction of the specific norms of international law. But what is the most important, and I would like to draw your attention to this 3rd feature, is this is creation of new norms. The modern international law, we call it the progressive international law, and we have a right to call this law as a progressive, because this law was created by whole members of international community and to the interest of whole international community. But nowadays we are witnessing when international law started to be created by very limited members and only for the interest of them. And I would like to insert the new term for this. Instead of progressive international law, we are getting regressive or even repressive international law. So, we still have progressive international law, but the process of its destruction and the speed of the creation of new regressive international law is amazing. And the regime change is the essential aim of the creation of this new repressive international law. And the only way for us is to protest it. First of all, we have to realize that this is happening, and the second, we have to protest its creation and to protest its treating as law, because obviously it is not law, but by the very fact it's treating as law, making it law. If international community will not do that, one day we will wake up and see no signs of progressive international law. The regressive international law will be the only law that the chosen states are making for us now. I thank you very much for your attention.